Well, kia ora koto, ko Steven Moe toku ingoa. Ko otatahi toku kainga inai nei, e roia toku tunga mahi o Parry Field Lawyers. It is great to welcome you all. We are very happy, very excited to be here. I'm joined by two of my amazing colleagues, and all of us work with startups every day. So I'll introduce myself briefly, and then I'll let you two introduce yourselves. I work as a partner here at Parry Field. We're a law firm based from Christchurch, but working across the country nationally. And for those of you internationally, helping people coming into New Zealand or have got questions as well. I've been practicing since 2001, started my career in Wellington, but I've also worked in Tokyo, London, and Sydney. So kind of have an international dimension. You can hear my accent, but I actually moved to Aotearoa when I was 7 years old. So grew up here. This is my home, my Turanga Waiwai, where I feel most connected. Yeah, it's a real privilege to be here to share with you some insights about startups today. Over to you.
Hi, my name is Yang. I started practicing since 2010. I'm also have a bit of an international background. I got my degree and my law degree in the United States in New York, and I got qualified in just last year after moving to New Zealand in 2020 with my wife and my two young boys.
Yeah, he was a COVID refugee, right? Yes, he was here when COVID started and he stayed, and we were lucky enough that he's now here with us.
Absolutely.
All right, Sophie.
Hi, everyone. My name's Sophie, and I'm a solicitor here at Parry Field Lawyers. I love supporting startups, especially startups that are doing something with a purpose, so doing a bit more than just making a profit. I also work across, so I work in the impact team with both Steven and Yang, and also do a bit of conveyancing and family trust work as well, so can support on that side too.
Yeah, so we're really glad to be here. For those of you who've joined since we started, feel free to use the chat. We would love to hear your questions as we go. And I just thought maybe we'd begin. We're really lucky. We have a bunch of questions that have come in before the session. So we're going to go through and make sure that we answer each of those. But I also thought it would be good to have a little bit of background on startups themselves and just some high-level insights from us. So the first point that I wanted to mention is really just thinking about the structure for your startup. And there's some key documents that I think you need to know about. So we ran a session similar to this one a couple of months ago. When was that? Just before Christmas? Or was it November? The months go by. Anyway, we recorded that one as well. And in that, we really went quite deep into capital raising, and we were answering lots of questions that people had about capital raising. But when it comes to structures, the thing is that there are different options. So the main one that I think most of you will be either already or you will become soon is a company. So just to touch on that, a company, there's actually only 3 things you need: a name, who the directors are, and who's the shareholders. So that's actually quite a simple thing to set up. And while we're doing this call, we could actually go to company's office and set up a company within like 20 minutes. You just have to get consent forms signed and things like that. But the core of it is that it's simple, it's easy to understand. And when you're seeking investment, it's probably going to be easier rather than choosing another legal structure like a limited partnership or going with a more charitable form like a trust or an incorporated society. So the 2 key documents that normally are signed or are helpful for a startup is number 1, a constitution. That's a public-facing document that anybody can access. It's on company's office. If you like a company, you can go look up their rules. And that usually sets out in a public way how the company will operate, how are decisions made. And then the second document is a shareholders agreement. And the shareholders agreement is an internal document. In other words, no one can publicly access it. Only you as the shareholders can have it. So some of you might be saying, but I'm a solopreneur. I'm just on my own. You probably don't need a shareholders agreement with yourself. but it's really useful if there's 2 of you, 3 of you, 4 of you, or once you get investors, maybe 10 of you, maybe 20 of you. So a shareholders agreement, at least it can be on your radar that that's something. Now, why would you have 2 documents? Well, the internal shareholders agreement, no one else knows what it says. So you can put whatever you want in the shareholders agreement, and you can have your own way of doing things. So for example, if the 3 of us were shareholders, you could access our constitution, but you wouldn't know that in the shareholders agreement, we have specific rules or ways of making decisions. We have specific rules about if Steven wants to sell his shares, he has to sell them to those 2 first, then he can go out. So there's different rules that you can put in. So I'm not going to dwell on that, I don't think, but I just thought it would be good to start with a brief intro on 2 key documents that you might have heard of and been wondering about. So hit us with your questions in the chat. We'll have that up looking as well. And we have these questions. I'm just wondering, maybe we should briefly mention capital raising. Should we?
Yeah.
Do you want to maybe talk about a little bit on that?
It's a good segue to go into that. Whenever you do a capital raising, the Constitution and the shareholders agreements are going to be required documents from the investors. That gives the investors certain comfort before placing their money in, right? So they want to know, okay, what is this company all about? You've told them, you know, in your presentations, in your PowerPoints, this is what we're going to do. This is our business plan. This is how we're going to grow. This is our 5-year, 10-year, 15-year plan. But investors need something that is legally binding and enforceable in order to protect their interests. If they're putting in $100,000, if they're putting in $1 million into the company, they want to make sure that that money is not just going into the void. They want to know what their protections are in the event that something goes wrong. Now, a lot of the financial and what we would call corporate governance type of protections are typically spelled out in the shareholders agreement because, as Steven has mentioned, that is a private-facing document. And because it's private-facing, you can have very, very frank provisions in there to say, as an investor, because I invested in your company, I get to appoint 1 director to the board, and the maximum size of the board of directors for this company is going to be 2 directors. That essentially means that there's a 50-50 power split for this company in this example, which gives the investor quite a lot of power. Now, obviously, all of this is negotiated between the investors and the founders, and it depends largely on the negotiation leverage of either side at that particular point. Valuation comes into it. Certain rights in order for the investor to either continue to invest in the future and or to be able to exit out of the company if they feel like the company is not going where they need to be going. That's also negotiated within the shareholders agreement. But I don't want you to be too put off by the breadth and the possibility of what can be included in a shareholders agreement. Within New Zealand, we actually have a fairly good market practice of following what we call angel association template documentation. And if you go on Google and you search angel association, they will have templates for both a constitution and a shareholders agreement. And also, before all of that happens, they'll have a template for what we call a term sheet. Now, what a term sheet really is just the memorialization and the documentation for the high-level topics that both sides want to discuss. They will negotiate based on a framework, which is the term sheet, and then that term sheet then gets translated into the full-fledged documentation of the shareholders agreement and the Constitution. So that's the reason why we feel that a shareholders agreement and a constitution are very, very important. It gives you the possibility of raising funds. No investor worth their salt is ever going to put their money into a company without having gone through the process of negotiating a term sheet, a shareholders agreement, and a constitution.
Yeah, those are great points. And you might notice in the chat that Sophie is somehow magically also putting links in. How do you do it? So she's got her laptop right here as well. So She just put in the Angel Association links, and we'll try, as we're talking, we'll try to put stuff in. So be watching the chat, keep the questions coming. Just answering Jessica's question there, does the shareholders agreement get revised regularly or updated? That's a great question.
That's a great question.
Yeah, we love that question. I think the answer will be yes, it should be an organic living document in the sense of if there's a new shareholder who comes in or new investor, they might have slightly different requirements to a previous one. So it's the type of document that shouldn't just sit in the drawer for the next 20 years. It really should be reflecting what it is that you want to do today. So yeah, that's actually, I view that that's the answer for all legal agreements. You always need to be revising and thinking about them. Are they relevant? Even with customers, like we signed this contract 7 years ago, we need to update it because things have changed. Yeah. Any thoughts on that?
Yeah,
Sophie or Yang?
let's just give a concrete example of when you would need to update a shareholders agreement. You would need to update a shareholders agreement as you progress in your fundraising efforts. So let's say you start at pre-seed and you're getting $100,000 from friends and family, right? You have a very simple shareholders agreement that is based largely on trust, right? Everybody has a good relationship with everybody else, but we do need something to write down what people's rights are. Your company has done very, very well. It now has gone from pre-seed to seed funding. Now you're getting strangers, right? Angel association investors and things like that, that want to get in on at that level with your company. They're going to require provisions and protections that are possibly ratcheted up another step. And that means that the original agreement amongst, for example, 3 shareholders is now going to have to be expanded to include a new investor or a couple of new investors. So all of a sudden, your shareholders agreement might get a little bit more complex, a little bit more detailed, and the provisions inside are going to include more protection for the new investor coming in. You're doing really well in seed, you go to the next level, right? Series A, Series B, VC funding. As you ratchet up the amount of funding that you're getting and the sophistication of your investors is getting higher and higher, the protections and the mechanisms that are included in the shareholders agreement will absolutely need to be updated. And that's not necessarily a bad thing, right? Because your company, as it gets more complex, as it improves in the way that it's running its business, it needs to evolve in that same directions for the protections for the company itself as well. The company itself needs to be protected vis-a-vis against the shareholders and the investors as well. And so all of this plays into it to be able to make sure that as you're growing, you are keeping up with the new realities of where your company is at and where your business is at. Yeah.
Yeah. And the other thing to mention, carrying on from that, is that when you first start, if you have a co-founder, everything is fine. We get the champagne out. This is amazing. It's going to be beautiful. What a great relationship we have. Test that 3 months from now, 6 months from now, a year from now. That's why it's really good to get those things decided when you first start, because believe me, when relationships have broken down, it's a much harder conversation to have. Hey, how are we going to treat each other? How are we going to make decisions? And we've seen that practically happen, where it becomes a bit of a minefield.
And just a very real life example, we recently helped settle a shareholders agreement dispute for one of our clients, and the legal cost for coming to a amicable resolution under that shareholders agreement, because it was something that neither party had previously contemplated, in order for somebody to get out, in order for the business to continue, the legal cost for that, for the dispute, to resolve the dispute, was orders of magnitude more than what it would have cost to spend the time and spend the cost to draft a much more suitable shareholders agreement, to be able to discuss these issues beforehand and to anticipate what the possible complications may be in the future. We received a question from you guys asking, hey, what happens if I want to incorporate a company with a 51% ownership and a 49% ownership? Well, this is one of those scenarios where it is critically important to lay out what the rights are vis-a-vis the two people. 51-49, you may think, oh, because I am 51% and the other person's 49%, as a 51% founder, I have full control, and the 49% doesn't have full control. That's not necessarily true. In fact, this is a situation where I would advise my client, you are effectively in what we call deadlock, as in day one. When we talk about deadlock, it's when decision-making at the level of the directors, at the level of the shareholders, is so balanced that if there is any misalignment, then all of a sudden the company stops operating, right? We can't even pass a budget. We can't even decide on who to hire, what our new business plan is going to be, who our suppliers are. We can't decide anything because both sides, even if it's 51-49, they are butting heads, and we call that paralysis and deadlock.
Yeah.
So that's one of those situations where you really need to think about why it is that you're giving 49%, for example, as a founder, right?
Yeah.
Why does it have to be so high, right? Or should it be even higher if, for example, they're bringing in a lot of wealth from their existing business or from their experience, right? All of these are things that need to be discussed and documented down.
Yeah. So hit us in the chat with any questions on that sort of a topic. If you want to know more about capital raising or you want to know more about founder documents, we're going to jump around here. We want to keep it interesting. And Sophie, I'd love for you to explain something which we get questioned a lot on. And that is, hey, I've got a team. I've got people who are involved here. What's the difference between an employee and a contractor? We're not employment specialists, but we know enough to be able to give you a little bit of guidance, and then we'll put in the chat a link to some information. But Sophie, can you?
And we do have employment specialists at Parry Field.
Yeah, we do. We have an employment team. We have 80 people in our firm. So we're just going to give you a little overview of that. So Sophie.
That's great. Thanks, Steven. So there is a difference between contractors and employees. So a contractor is somebody who might be brought in to do a very specific piece of work. It could be a particular project for a particular amount of time, and they themselves then set their own hours and decide when they're coming in, and they will invoice you for that work, versus an employee. So as an employer, you would hold all the obligations under like the Holiday Pay Act and sick leave and all those different things for that particular person. So an employee is, you have a lot more obligations as an employer than you do as somebody who is bringing in a contractor. But then there is a grey area as well. So you start off with a contractor, that sort of relationship, but then you give out business cards that have the name of your business on it, and you require them to be in your office on certain days. So that's the sort of grey area that our employment team would be amazing at helping you out with. Because you've got to be really careful to make sure that you keep that distinction between a contractor and an employee.
And Sophie, can you just touch on another thing? It's kind of underlying what we're saying. Yang mentioned it before, document it. Why should people record things in writing, like contracts, for example? Can't we just use a napkin? You know, like I know that person, I trust them. Why should they be putting things into contracts?
Absolutely. It's really important to have things like this written down, because it's a written record of the relationship that you have with the person. So if they are a contractor, then that agreement, if it's written down, it would set out what it is that they're being brought in to do, what your obligations are and what their obligations are. So that way, if there's any issues going forward, like Yang was saying with shareholders agreements, actually there's a document there that you can refer back to that records the services that they're providing and the amount that you're paying them. So that's really important. And if you're employing people, it's even more important, because you have certain obligations as an employer, including around an employment agreement with that person.
Yeah, that's really great. The other thing, of course, is that when you come to have investors, what are they going to want to see? If you go to an investor and say, hey, I've got an amazing idea, would you invest $500,000? And they say, okay, well, where's your contracts? And you say, we know those people really well. And Oh, how about your IP? Do you own your IP? Well, we have it in our heads. Like that's going to be the first question that the investor's going to want to know is, do you own what you say you own? Do you have contracts that back up the flow of money in? So you're doing yourself a favor from the beginning of your startup journey to document things well. I would even suggest you save things into folders right from the beginning. So customer focused contracts, supplier focused contracts, employment related, governance related, IP related. Those are all things that you're going to have to, at some point, be accountable for if you want to get an investor coming in. I'm just wondering, one of you was asking about should you set up a company at all, or should you just stay as a sole trader? Do you want to maybe touch on that one?
Yeah, sure. This goes back to the history of the formation of limited liability companies.
Yeah.
We don't throw people in jail anymore because they owe money, but that's what they used to do. And so historically, it became very difficult for people to take on liabilities that were greater than their means, even though the risk warranted it, because the consequences were so dire. In finance, we can almost think of it as a black swan event, something that is so small of a chance, but the consequences are so big that it impacts and influences the way that you do your decision making. And that's where the birth of limited liability companies came from. What the legal system wanted to encourage was to encourage innovation and calculated risk taking. So when you say, okay, should I start my business as a sole trader or just not even set up a company because I don't even have the funds to pay for registration with the Companies Office? The downside to that is you don't benefit from what we call in the legal world, the corporate veil. The corporate veil is what protects you from personal liability. So I can be a sole shareholder, I can be a sole director of Yang Limited, right? For the entire world, the operational aspect of it is just me. I'm providing services, but everything that I do is signed on behalf of Yang Limited. This company is entering into all the contracts with my clients, is entering into all my contracts with my suppliers. This company exists as a separate legal person. The legal system recognizes that this company is an other from me. Even though I am the sole shareholder, even though I am the sole director, this company's liabilities and also its, the earnings that it contains within itself are separated from me. This is very important because I personally own a car. I personally have my own bank account. I have my own house. But I want to go into business. I want to take risks because I see the upside of it. In the event that the risks eventuate and the company goes under, because bad things can happen in business, what the corporate veil does is it protects my personal assets from being lumped into the liabilities of the company. So the company will owe the supplier money, right? The company will owe rent to the landlord because it rented some offices. But the landlord and the supplier cannot come and enforce against me personally and say, hey, Yang, you have a house. You need to sell your house in order to pay for the debt that you owe. That's the genesis of the corporate veil and why we highly recommend for the right legal structure. It doesn't necessarily need to be a company. It is the most common, but we recommend for the right legal structure to be implemented for your business.
Yeah, that's a great answer. And if you think about the origins of even like surnames, in English speaking world, there was the Smiths and, it was related to that's the local Smith. And so if you had a business, you put everything in. If you lost your business, you lost everything. So it's really it's an amazing innovation if you think about it. We live in a historical moment in time when there exists a legal fiction called companies. Like they didn't exist. If we went back hundreds of years, thousands of years. There was no such thing, but we made them up to encourage entrepreneurship. And just picking up on that theme, one of the things that we do advise you to do is consider, if you think it's going to be successful, how do you own your personal assets? So I liked your example of the car, you know, like the car's in my name. Should your assets be in your name? So some of you might already own a home, for example. If you're setting up a business and there could be liability that flows, one of the things, and talk with your accountant, your tax advisors, but one of the things you could consider doing is setting up a family trust. And this is, again, ring fencing of liability. So when I became a partner in the law firm, I set up a family trust. The family trust owns the home that I live in. Hopefully it will never happen. But if a claim was brought against me, guess what I would say? Oh, you want some money from me personally? Well, that house over there, that's not my house. That's my family trust's house. So if you looked at the wealthiest people in New Zealand, I think you'd find that they actually had small amounts in their personal bank accounts. And it's because they are aware of the benefits of having entities to ring fence liability. So it's just something to be aware of. And following on from that, I think there's a ridiculous statistic about how many people have wills and how many people have enduring powers of attorney. It's like 40%. So some of you don't have a will or don't have an enduring power of attorney. A will sets out what happens when you're no longer here. For better or worse, none of us will be here in 100 years, right? So having a will is a gift to your family to say, this is how I want things to be treated. And an enduring power of attorney is, if I get hit by a bus, who's going to make a decision on whether I stay on life support or not? You know, like those are big things. So each of you should have an enduring power of attorney. We can help with that. Your local law firm can probably help with that. You might have someone that you know personally, but it's something that we do a lot of, a package of a will and EPAs. They cover your health and your property, 2 EPAs. So really important just to mention. I know it's not purely on Startup World, but I want to keep you safe. Ultimately, that's what we're trying to do. So these are things to keep you safe. So Sophie, I'm just wondering, one of the questions was asking, and this is actually from a friend of mine up in Tolaga Bay doing some amazing work. And I'm just wondering if you could look at this question. He's asking about a company being set up, which would then be owned by, I think, a charitable trust and maybe some other investors. Is that possible? Any issues with that?
Absolutely. So a company can be owned by a charitable trust. We would suggest that, like Yang was talking about with the limiting the liability for a company, you can also register a charitable trust with Companies Office. So it's incorporated and it's its own entity. So we would also suggest doing that. So that way, yeah, it's incorporated, it limits liability for the trustees, but that charitable trust can certainly own shares in the company. The charitable trust will need to be aware of its own trustee to make sure it uses any funds that any dividends that it makes from the company, any profit, to then advance its own charitable purposes, but it is able to own shares in a company.
Yeah, and that feel free to riff off of this, but that's what you're talking about is what I call a hybrid structure. So a hybrid structure is using both charitable arm and for-profit arm. So some people use the term social enterprise. I actually did we print it out? I wrote a book on social enterprise. If anybody's interested, that's the cover page. So we know quite a lot about social enterprise. I've personally have moved away from that term. I prefer the term impact company because I feel like it's a bigger umbrella. Like social is only for social things. What about environmental? What about other, cultural? And so I prefer the term impact company. But I think the way of the future is that entrepreneurs realize that they can use the tools in the tool shed of different legal structures, one being a company for profit, the other being charitable. Because for the vast majority of you entrepreneurs, you're probably incorporating something to do with education, the environment, reduction of poverty, health and well-being. all of those things are potentially charitable, because this isn't a talk about charity, but there's 4 heads of charity: advancing education, reducing poverty, advancing religion, and purposes beneficial to the community. So a hybrid structure recognizes that and says, actually, I would like to take advantage of the tools and set up a charitable arm that complements my for-profit arm. So we're not going to go into lots of detail there, but we've written a vast amount on this topic. And so if you're interested, yeah, the book's probably a pretty good place to start. Yeah.
So Hannah has a question here, going back to our discussions about why is it recommended to have a family trust if your company is already providing ring fencing? You're going to be wearing multiple hats as a founder. You have a founder's hat, you're doing the business yourself, but legally speaking, you're likely also to be a director of the company. Under the Companies Act, there are certain duties that a director needs to meet when running a company. These are called fiduciary duties, and they're found in Section 130s and the 130s in the Companies Act 1993. If you breach your director's duties, then you are personally liable for that breach. I don't know if you guys have heard of the Mainzeal case, but in that case, our former Prime Minister, Ms. Shipley, she was found to have breached her director's duties in acting as a director for Mainzeal, the company. The difficulty with that is that when you breach your director's duty and liabilities attached because of your breach of director's duties, that is a personal liability. So if I, Yang, as a director, am found to have breached my director's duties by recklessly trading while my company was insolvent, for example, if the house is under my name, then I own that house. And if the judgment for my breach of director's duty is $1 million, I have to liquidate my assets in order to satisfy that judgment, right? As Stephen has said, if on the other hand, if the house is in a family trust, is under a family trust, then again, that's not my own personal asset, and therefore personal liability that attaches to me cannot touch that house. There's other examples as well. Within the practice of New Zealand, it is quite common for leases to require personal guarantees. Mm-hmm. So if your company is renting an office because you guys have grown and you need an office, right? Let's say the rent is $100,000 a year. Landlords typically will not take it at your word and just trust that your company is going to be able to continuously generate enough profits to pay that rent, particularly if the lease is for an extended period of time, for 10 years, for 5 years, 10 years, even multiple renewals, right? Therefore, the landlord is going to say, well, okay, you are the main shareholder. I would like for you to sign what we call a personal guarantee to guarantee the obligations of your company to pay the rent, right? So in the event that the company no longer is making as much money as it used to, the landlord can go to you personally because you signed this personal guarantee and say, hey, I would like for you to now pay the rent that your company owes me, and I'd like you to satisfy it personally.
Mm. Yeah, that's awesome. And I saw you were getting up the Mainzeal description, so we'll drop that in the chat as well. So we did an article about Mainzeal and its implications. It's a fascinating case, like the ex-prime minister liable for $6 million. Wow. So there's a lot of good content there that will help you. As a side note, governance is a really important topic, and that's something we do a lot of work in. I'm a facilitator for the Institute of Directors, and so I do a lot of work with them training people about governance. Do you mind putting the Board Matters link in? So I did a podcast for the IOD called Board Matters. It's in Spotify and Apple Podcasts, 10 to 15-minute episodes about governance, the key things you need to know, speaking with really experienced people about their journeys as well. And yeah, just to echo the liability point, you're going to have to get used to something, which I view it as a nice metaphor, which is the hat that you're wearing. I think you mentioned it. Like, Am I wearing my shareholder hat? Am I the director hat? Am I the employee hat? Like, which hat am I wearing? And we're trying to give you tools that will help you to minimize your liability. So it will be better for you if you take on board some of these concepts, assuming, of course, if everything goes well and you're in the next Facebook, it's not going to be an issue. But if things go wrong, which sometimes happens, right? It's better that you're aware of these things. And the personal story on this, Sophie and I just helped actually 2 entrepreneurs push back on the request for personal guarantees, because we told them you should push back on the landlord and tell them you're not willing to guarantee it. And they were both successful. So I was actually quite surprised. I thought the landlord was going to come back and say, yeah, but you're a startup. We need you to personally guarantee it. But they did not. So it just shows that there is some, well, particularly in economic climate, they might be desperate to have a tenant come in. So push back where you can. Don't personally guarantee things. I had another person that we didn't advise them at the start, right? They came to us when everything was going wrong. 10-year lease, large amount per year, cafe, business tanked, personal liability for that lease for the next 10 years. So this is why it's really important to be thinking about these things and be aware of them. So Sophie, we're jumping around here, but we hope that this is helpful. Keep the comments and the questions coming. We love to see the interaction there. And Sophie, I'm just wondering, can we answer that one? We got a question about, I guess, about investors and when do you start disclosing information to other people who might be interested in your business? You want to start us off on that one?
Absolutely. Thank you, Stephen. So when you start that conversation with investors, there is a lot of trust involved. So we're talking about a situation where, you've pitched and an investor is interested in you. So there's a lot of trust involved at the beginning of that relationship. And it might even be that you need a non-disclosure agreement in place as well, where you both agree to actually not disclose anything further, disclose any sort of conversations that you're having outside of the 2 of you and your legal advisors. And that's generally how things start. Yeah.
Yeah, I think that's the key word, is the trust element. Like, the other big part of this is you got to trust your gut. And what I mean by that is, don't just chase the money. Don't just chase the first person who has some money to invest. There needs to be an alignment of values, because one of the worst situations that I've ever seen is where startup founder, this is their life. This is their baby. They allow someone to come in and invest. They get the money in the short term, but they're then in with this person that actually is only there to scale it and sell it. And so there's this massive misalignment between the values of the investor and the values of the founder. So don't just chase the easy money. Spend your time. I know this is hard, but this person is offering me a lot of money. But you're going to regret it unless you can make sure there's a due diligence both ways. They are investigating you. You should be investigating them and making sure that there's going to be that alignment. And if you don't trust them, if you can't give them the information on your company and you don't feel like they're going to use it well, that's an early indication that maybe this isn't going to be the best relationship. So in the chat, somebody's asked a great question. Looks like Carrie, asking about some IP. Yang, do you want to jump in on that?
Yeah, so intellectual property is not just a new invention. In fact, some of the most valuable intellectual property around the world is brand recognition. Just this year, you guys would have probably read that Disney lost its rights for Steamboat Willie, which was the first animated series to feature Mickey Mouse. So now all of a sudden, in the United States anyways, Mickey Mouse is now what we call, it's in the public domain. And so people can use it without having to pay or get the permission from Disney to be able to use Mickey Mouse. And in fact, if you're like me and you troll through YouTube late at night, you will see a lot of memes are now starting to use Steamboat Willie, because they can, and they don't have to be afraid of, you know, getting struck down by a cease and desist letter from Disney, right? Intellectual property is oftentimes the core value proposition for a startup. What you are bringing is a new idea, a new approach, a new process, a new way of doing business, right? But not everything that you come up with that is new is protected in a legal sense. For example, if you're writing new software in New Zealand, right, the code that you write is actually not protected under patent law. Patent law in New Zealand is focused on protecting new inventions, and New Zealand does not recognize the writing of new code to be an invention. And therefore, the type of protection that you would be looking at for your code, for your software code, would be copyright, which is what we typically think of when, you know, we write a book or a novel, then we have a copyright protection for that novel that we've written, right? You might be thinking that there might be a inventiveness or a innovative process for doing something. All of that needs to go through, if you want to get patent protection, it has to go through an examination by the patent office to see whether or not what you've done is novel, it's new. And then after going through that process, will you get the protection that you are asking for. Seeking patent protection itself is not a swift and easy process. In fact, it's actually a very specialized field of law, and we partner with a lot of patent firms around New Zealand to help us and our clients go through that process to try to get patent protection. The one that you will definitely, the type of legal protection that you'll definitely want to explore very early on is trademark protection, right? Your business has a specific brand, right? Your logo, your name, right? The product that you come up with, right? It has a cool design, right? That is also intellectual property that you should be looking at to protect. And there are various ways that we can go about that, but trademark protection is usually what we would recommend to our clients. And you do that through IPONs, right? You file a trademark application, it gets examined, et cetera, et cetera. Now, the question then becomes, well, how do I know when I need to apply for this protection? It largely depends on what your business model and what your business model is and what your plans are for the near future. If your company's finances does not allow you to be able to spend on protecting that IP, and that IP is not crucial to your business, right? Then perhaps you might be able to wait for some time before you apply for intellectual property protection. Having said that, investors know that the basis of their investment is the newness of it, right? The uniqueness of this particular company. So if you can show potential investors that you already have up and running trademark protection, copyright protection, patent protection, if it's an invention, then that actually helps in your valuation of your company, because your company is going to own that particular asset, and you're able to look at the investor and say, this is a huge asset that we own. This is the core of the business. And I already can tell you that I'm protected against copycats. I'm protected against people that are going to try and replicate my model because I've already gotten the legal protections, right? So that's the balance that you sort of have to look into.
Yeah, that's awesome. The IP is definitely something that people need to spend time on. One brief thing, some of you I know are just starting out. I've had entrepreneurs who work on their idea for 6 months, a year. They didn't do a simple thing. Google your name or your hope for name and make sure that nobody else has it. I've had an entrepreneur start in their mind, they're dreaming about this particular name. Their soul is connected with this beautiful name. And then somebody points out, oh, someone else has that name. They're already registered. So just take a bit of time and check if your name is even available. And then the one counter to what Yang is saying is that sometimes the best protection is secrecy. Don't tell anyone what you know. So Coca-Cola is the great example. No one knows the recipe for Coca-Cola because they didn't tell anybody. So that's an example of actually keeping it secret, keep it hidden, don't let people know. Sometimes I encourage entrepreneurs, just get out there, do the best you can, become so good that if somebody copies you, you take it as a compliment because you're so much better than anybody else in the market. I see lots of entrepreneurs getting hung up on IP and protecting it, and they end up, oh, we got to go to court to protect against this person. Just get on with your business and become so good that they're in awe of you, and it's a compliment that they're copying. It goes, obviously, you want to protect yourself. I'm just saying sometimes entrepreneurs get too caught up in it. So we're getting towards the end here, just in terms of time and things. Sophie's put a link to the One Check place where you can go, government website, tells you what's registered or not. And we're just going to turn, there's one more question we had before the session. If any of you have a question, drop it in the chat now because we'll be closing off pretty soon. Before I answer this question, I want to make sure to have mentioned we have lots of resources. Sorry. So this is one called the Startups Legal Toolkit. And I recommend that you, at very least, flick through it. When we wrote it, we tried to make it as non-legalese as possible, but that covers a lot of topics that we think will really help you. So I'm pretty sure it's about to be put in the chat. So that's that one. So have a look. And then we've also got this capital raising key issues for founders. So you're welcome. What we're trying to do is resource the ecosystem. Whether you come and use us for legal support or not, we want to support startups. And so these are resources which are just out there. They're publicly, freely available. Feel free to pass them on to other entrepreneurs you know. It will get you thinking at least. And that's really the intention behind it. So yeah, the one other question that we had here, and we can...
We'll talk about this one,
the
share options.
The share options. Oh, do you want to... Yeah. Well, do you want to mention, so the share options, I think it's actually put in the chat as well. And so the question was just about, I'll go down.
It was about, can you share some insights on what to look for in a share options contract? Shares versus options. Do you pay tax just once when you exercise them? And are there any issues to look for?
Right. You want to grab that one?
So shares and share options. All right. So I think what we're really talking about is getting equity in the company, right? You want to get some sort of ability to be part of the shareholders of that company. Oftentimes, the reason why there's a difference between getting shares versus getting share options is because the person that is receiving the options or the shares does not have enough money to pay for those shares, right? Or the shares that are being provided to the prospective shareholder is provided in terms of an incentive. So it's part of the incentive that they got because they have been employed with the company for a long time, etc. At the end of the day, an option is only good if you exercise it, right? So an option is the ability to do something. You have the right to do something. And when share options, what we're talking about is I have the right to exercise my options in order to get some shares. However, that does not mean that just because you exercise your options, the shares are going to come to you all of a sudden. No, it can come at a price, right? So for example, options for shares might happen on a vesting schedule. So you can, if you're going to be given an option for 100 shares, you need to basically work a year before 25, you can exercise your options for 25 shares, right? You need to work for 4 years before you can exercise options for all of your shares, right? When you exercise your shares, there might also be an exercise price, right? So you might need to put in some money in order to turn those options into shares. The difference with getting shares outright is you're basically just purchasing them, right? You don't have to go through the rigmarole or jump through the hoops of changing an option into a share. You just say, okay, well, this person is offering me some shares in the company in return for me paying the money right here, right now, right? Options have the possibility of, not being able to be exercised because you receive some share options, but 2 years down the line, before your options vested and you were able to exercise them, the company has gone bankrupt. It's basically gone insolvent and it's had to be wound up. Well, you have options to get shares in a company that doesn't exist anymore. So those options are worth nothing, right? With regards to the specific question as to tax, right? As to what the taxation treatment would be for either shares or options, the IRD is very aware of people trying to use options that are done at an exercise price of a low price in order to get around receiving a valuable benefit for nothing, right? So you will have to take accounting advice from accounting and tax experts in order for them to advise you correctly as to what the right option, for what the right structure, for what the right approach is for you to be able to receive these shares, right? When you purchase a share, it's very simple. You take your money, you're getting shares in return, right? The entity that receives the money is actually the seller. So the taxation treatment would be on either the company receiving that money for share issuance or on a fellow shareholder if they're selling shares to you. You're getting something in return. So that's the short of it when it comes to shares versus share options. Options by themselves, as I've said, are not amazing until they turn into shares because you have that risk of the options expiring or not being exercisable in the meantime.
That's great. Thank you. Yeah, so as you can tell, we've covered a lot of different topics. There's been a lot of different little rabbit holes that we've jumped into. We hope that this is really helpful. We have recorded it. Somebody asked, will it be made available? And yes, we'll put it on YouTube so that it can be shared. If you're willing, then please tell other people about the content and the resources that we make available. It's something that we just want to allow other people to access to get better information. The other thing is that by signing up, you didn't know it, but you got a 2-for-1 deal. So we're really happy to have not hour-long conversations, but brief conversations with any of you if you have a specific question. The 3 of us are here. You've now met us. Just drop us an email. We're all copied on the one that had the link. And then we can just set up a little call, have a conversation, 10 minutes, 15 minutes, that's fine. Then if we can support you with more detailed stuff, then obviously we're happy to do that as well. So we really hope this is helpful. Sophie put in a link to the podcast I do called Seeds Podcast. Why not go check it out? There's 383 conversations now with entrepreneurs and others doing inspiring things. So it's a lot of good content. It's in Apple Podcasts, Spotify. Leave me a rating and review. It helps other people find it. And yeah, we just want to say thank you. You've given up a lot of your time today, and we hope that this has been really helpful. And we wish you all the best on your entrepreneurial journey. So thanks, everybody. See you later.